Please, Your
Yes.
Lordship. So 483 bail application. In fact, it's the second bail application preferred by this petitioner, my Lordship.
First petition.
It's a second bail
Sir,
application. my Lordship. It's a POCSO matter, my Lordship. Notice might be required. Steps.
just a minute. I'll just check it once. POCSO. Sure. Your Mr. Doctor. Your good name, please.
I'm PS Raja, my Lordship.
P.S. Raja, Learned Counsel. And Kaushik, learned additional people. Full stop. It is fairly submitted that an earlier bail petition was rejected on 24/11/2025 in BA 3427 of 2025. Full stop. At that time, we had perused. It's at a stage of trial.
Yes, my
Trial is
Lordship,
going on.
It's in the stage of trial, my Lordship.
Trial.
Someone has been issued on the repeated times, including the victim and her family also. Nobody has done that. And court is 2 kilometers away from their residence, my Lordship.
Pardon?
Court is 2 kilometers away from their residence of the victim as well as her families, my Lordship. They haven't turned up.
Okay.
And trial has begun in the month of May.
Bongaigaon, right?
Yes, it's Bongaigaon.
Bongaigaon. So what we can do is we call for the scan copy again and a status report.
And notice has to go, man.
Or notices to be. The petitioner side shall take steps for issuance of notice to the informant. Respond number 2. Such steps should be taken to the office of the public prosecutor and to be executed through the concerned police station. Prosecution may also take steps, instructions regarding service subsequently. Stop. We have the scan TCR received earlier, right? So actually update is, otherwise it will be a repetitive exercise. But what do you suggest? Usually once they scan it, they also keep it in the computer. This is also true. Call for the scan TCR of special POCSO case number 31 of 2025 from the learned special judge Bongaigaon, including updated later, including up-to-date relevant documents. Good stuff. Status report will be included in this. It will be scan record will reveal the status. No need separately. Is it? What do you say?
Also, we report with regard to service of someone may also be required, my Lordship, because that will come from our office. Someone.
To the witnesses.
To the witness.
No.
I have the.
Okay.
It will reveal from the orders, man.
As the learned counsel for the petitioner submits that despite repeated summons, some of the prosecution witnesses have not turned up. Therefore, the learned trial court is requested to send a status report regarding the stage of the trial for the purpose of adjudicating this subsequent bail application. Okay. This is the matter on after. You can suggest a date.
In the first week of March.
First week of March. Let it be on 9, because I will also not be there, because this I have to take up, right?
Yes, my Lordship.
9. I'm going to ISO. So
Obliged, man.
microphone has to be checked. I'm not hearing properly from the other side. Am I audible? I'm audible. I'm not hearing properly from the other side. Slightly. Anyway, we can continue.
May I please, your lordship?
No, item number 2, I could not go through the scan copy, my lord.
Item number 2, no, this one. Any more motion? No.
Last occasion, your lordship directed the jail authority to submit the status of the transit remand of the petitioner, my lord.
Right. Oh, so that case, right?
My lord.
I see. Case map has been received.
Sorry, man, I could not go
No,
through the,
yeah, no,
I
no,
was
it's,
there in.
no, it's received, reflected in the last order. I think you had not appeared, or Borua had appeared. He's looking after, will he look after this matter? Then he had submitted on this, on his submission, I had recorded, scan copy has been received, but that status regarding his whereabouts, because he has a case in West Bengal, this person.
Oh, my lord, through registry, my lord. It is,
No, Superintendent Central Jail Kasar.
then,
Today
No.
morning, my lord, I have contact with the wife of the petitioner, my lord. She is now at Silchar jail, my lord.
He's at Silchar Jail now.
Silchar Central Jail.
Okay.
So your lordship may take up the matter day after tomorrow, my lord. The undersigned will also appear, my lord.
It is, can I record that, Mr. Alam?
My lord.
Mr. Alam submits that as per his information, the petitioner is presently lodged in the Central Jail, Silchar. And further submits that perhaps the matter can be proceeded with. Mr. Kaushik, learned additional PP, submits that he needs some time to go through the scan record. Okay, no problem. Day after tomorrow, we take it up. Yeah, I think I will have single bench day after tomorrow also.
My lord.
This is the matter on, it will be which date? 6th. 18.
18, my lord.
18.
Number 3.
Is connected now. No. Lopez.
May I please, your lordship?
Yeah,
Lordship, in this matter, senior counsel, Mr. A.M. Bora will appear, lordship. So matter may be taken up after some time. He is on legs in court number 22, lordship. Lordship, after some time, lordship, he is on legs.
okay. Tomorrow or day after? Yes, tomorrow or day after? Tomorrow? Subsequent bill application. Subsequent bill application. I just make a note for my reference. Okay. Earlier bail petition was rejected on 9/1/26, class 10. BA 4108 of 2025. He's on custody now. This one. They're in custody.
Lordship.
Because from this order, earlier one order was rejected in AB, then perhaps this was filed. Okay. BA 4108, the case diary has been received. But Mr. Kaushik learned additional PP seeks some accommodation to go through the case diary. Now you work it out. I'm ready to take it tomorrow. You're for the informant, Mr. K.M. Learned counsel appears on behalf of the informant side. So I'm agreeable tomorrow, day after, both is okay for me, but you decide whatever.
Tomorrow, lordship.
Tomorrow. Any case, it will be second half. So you'll get some time. But you have to be there, I think. So,
then in DB, the other 2 hearing will be conducted. So,
Yes.
I'm supposed to come here.
no, managing to TB and singles difficult.
Obviously.
For you, I'm saying, for you. We are used.
Second bail application, so earlier was rejected by.
Yes, that's why.
Today is the date fixed for case diary, lordship, and we are 76 days.
76 days.
on that. But the final postmortem report has not been received, my lord.
What's this? Yes. Mhm. Mhm. Earlier bail application was rejected on 4/2/26 in BA 27 of 2026. Case diary is received, you said? Oh, updated case diary. We can do it?
Report is not received.
Okay.
It was sent for FSL, my lord. That report has not been received.
That will be necessary. Because he's already spent 76 days. What is the, Because I see I'll be going to Bhopal. I have to leave on Friday. Friday, I will not be able to attend court. And from after Bhopal, I have 2 weeks in Aizawl. I am coming directly to Aizawl. So, last day also I do not want to because I have to complete everything and go. What will it come? Case diary is, Mr. Kaushik submits that the case diary is received, but the final PM report is not available and seek some time for the same. Prayer is allowed. The said document may be procured. At least the matter day after tomorrow. 18. It can be liquid. Yeah, Mr. Actually, we are not remediless in this kind of situation. Sometimes these matters can be heard through VC also. The person doesn't have to languish. Suppose a matter is ready to be heard. The only thing is I don't know, I cannot see the CD. And then no problem. If the prosecutor sees it, studies it thoroughly and argues, no problem. It can be, but the matter does not have to remain, pending and someone remaining in jail because we can work. I've seen, we can hear through VC also, but this matter will be here. We'll be able to do it Wednesday only. But just for,
If he gets in a WhatsApp also, Lordship, be very.
as an option, I'm saying, it's
Okay.
as an option. It should not be fixed late. You can hear in between. Anyway,
Much obliged.
Item number 7.
6.
6 in hearing.
Oh, how nice. PGOS as a report. 7. 6 or 8, no?
May I please, Lordship?
Yes, yes. That matter, no?
Yes, Lordship. Lordship, the charge is framed under section 21C of NDPS.
Now it's okay. Audio is okay now.
Yes, Lordship. And the allegation being that 2015 grams of morphine was recovered from the petitioner, Lordship.
That would be
Basically-
probably commercial quantity.
Yes, Lordship, 21C. So basically in this application, Lordship, I'm pressing on mainly on 3 grounds, Lordship. First being that there is violation of section 48 of BNSS, corresponding section 50A of CRPC, that no notice under section 48 of BNSS was issued either to the friends or relatives or any nominated persons of the petitioner, and that there is violation of the fundamental rights of the petitioner guaranteed under the Constitution of India under Article 22(1), and also violation of the guidelines of the Apex Code in the case of Vihan Kumar and Prabir
Right.
Prakash, Lordship. And the other side, the respondent side has also submitted they have filed their objection, Lordship.
Okay.
It is before your Lordship. In that objection also, Lordship will find that not a single whisper has been made that they have furnished 48 notice, or if they have, then whether it is in the record or not, and if not, why they have not furnished a 48 notice, Lordship. That not a single whisper is being made in the objection, Lordship. The second ground on which I am pressing is that in the instant case, Lordship, section 36 of BNSS is not properly followed. Lordship may kindly see the arrest memo, which is at page 61 of the petition, Lordship.
Page?
Page 61, Lordship, that is the arrest memo.
Yes.
Lordship, as the mandate of the section 36, it lays down that in the memorandum of arrest, at least one witness signature has to be obtained, who should be the member of a family of the family member of the person, or a respectable member of the locality where the arrest is made. Lordship, if Lordship peruse the arrest memo, very lamely two signature has been taken, Lordship, at the bottom, if Lordship peruse. Whether those are independent witness or not,
Some,
yes,
by
Lordship. Whether
Noyon, this appears to be Noyon Ray.
Notion Ray and
10-3 that Ray.
yes, Lordship. So very lamely that the signature is being obtained. So 36 of BNSS is not properly
Some
followed.
signature is there. Right?
Yes,
Some
Lordship.
signature is there.
And section 62 of BNSS clearly lays down that no arrest shall be made except in accordance with the provision of BNSS. Therefore, in this case, there is a violation of that
But
mandate.
there are two signatures. But you
Yes,
have to
Lordship,
see,
but
no?
very lamely taken.
Signature, LTI of person, signature of person arrested, signature and so.
Yes, Lordship.
But
Whether it's
anyway,
an independent person or not.
it will be, there has to be seen anyway.
Yes,
Uh,
yes,
there
Lordship.
is-
The third ground that
Just give me a tag. Okay, third ground.
I'm pressing is that the charge sheet was submitted on 10/3/2024, Lordship. However, till date, not a single witness has been examined. So basically, I'm pressing on
No,
the ground of
that's the
prolonged
problem.
incarceration, Lordship. As of today, the petitioner has spent 708 days behind bar, Lordship.
Charge sheet.
And in this,
As you know, madam, as you know, actually there's no clear cut position is not yet laid down as to how much should be taken as a long enough incarceration,
yes, Lordship. Lordship,
to trigger Article 21, including the latest case from Supreme Court.
Lordship, may I place before your Lordship two judgments and one order of the coordinate bench? May I, Lordship?
Sorry.
In this ground, my lord, I want this, they have stated that two signatures are there, whether they are independent witnesses or not, they are not sure. But these two signatures is Ritura's Bailung and one Noyan Ray. Both are,
Just a minute. I'll come to it. You have completed?
No, Lordship.
Oh.
I'm
I'll come to
pressing-
you, ma'am. Welcome. This is from your side, petitioner.
Lordship, I'm referring to the judgment of Mohammed Muslim alias Hussain versus State and City of Delhi. Lordship, may kindly see page 8 of the judgment, para 20, last line, Lordship,
Okay, just come.
which states that grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37 of the NDPS Act 1985. Moreover, Lordship, I'm also referring to Ravi Prakash versus State of Orissa, para 4, Lordship, which says that the prolonged incarceration generally militates against a most precious fundamental right guaranteed under Article 21
Certainly.
of the Constitution.
This is which para?
Ravi Prakash, Lordship, the paragraph is 4, para number 4 of Ravi Prakash.
Yes, yes. Para.
Article 21 of the Constitution, in such a situation, the conditional liberty must override the statutory embargo created under section 37, subsection 1, clause B, subsection 2 of the NDPS Act, Lordship. And also I have placed before your Lordship one order of the coordinate bench wherein the petitioner was granted bail and his length of detention was 663 days, Lordship.
By this court?
No, Lordship, that is the
Supreme-
coordinate bench.
In this case, the bail was allowed, I think,
Yes, Lord.
in this case.
663 days on the ground of prolonged incarceration, Lordship.
Because why I said this, actually, because so we find two sets of decisions where one set of decisions, prolonged incarceration, this certain period, 2 years, 3 years, have been, held to be sufficient to trigger Article 21 and bail has been granted. We have another set of decisions where, despite some considerable, length of detention, it has been held that the bail has not been granted. So
Yeah.
that's the thing. We do not yet have a in my humble opinion, authoritative pronouncement on that point.
Yes.
And the recent case, of course, the Honorable Supreme Court has never said that this is a precedent regarding that Khalid case. It's never said that it's a precedent, but in that particular case, on the facts, about 4-5 years was also not considered sufficient to trigger Article 21. Again, I mean, saying that the apex court has not said that this is going to be the precedent, not at all. It always depends on the facts.
Yes.
But that is, but in another case, the apex court may take a different view. So we do not really have these things cannot be measured also.
Yes.
How much detention, under trial detention is sufficient to trigger Article 21? That is actually an unfair question, because ideally a person should not be in under trial detention for any longer that is necessary, absolutely necessary. So that is not a fair question for me to ask also, that how much will be sufficient. There's nothing like that. But will be benefited if there is a clear authoritative pronouncement or something. Again, it's difficult, and I'm saying it's very difficult it will be very difficult for apex court also to say that 2 years, 3 years, that will be problematic, because a particular situation, a person may have spent 2 years, but he may be having a lot of personal difficulties, family, health. For him, 2 years may be enough. So it will be risky to lay down anything. Yes. So yes, because absolutely right. So it is risky also to lay down. So it will therefore always depend on the facts and circumstances, which helps your case. That it always depends on the facts and circumstances of the case. Because this is a general principle that if you do not give me bail, you must expedite trial. You cannot
Yes.
say that I will not give you bail and I will
execute
not
the trial.
progress with the trial also. That cannot be.
Exactly.
That cannot be. Hmm. 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 Oh, not. Anyway, sorry. So sorry for the digression, but this was in the context. Okay. So I have written down your 3 grounds. No progress of, not a single witness examined.
No, Lordship. That means.
I will come to man.
Exam-
As per your
exam-
instruction, it has not started.
No, Lordship. I have also seen the TCR. So
Goalpara, right? This is.
The accused didn't engage any counsel actually at earlier stage. So the witnesses cannot be examined at that point.
Anyway, so. Next.
Lordship, this
This
is my
much.
humble submission.
You can reply. Like, madam, sir,
Yes.
then you can reply.
Yes, Lordship.
And this time they have raised the issue of notice under 48. In earlier cases, they never raised this issue.
Yeah, because these things.
Earlier, different counsel was engaged. For the first time, we are representing the petitioner in this case, Lordship.
All of us were not so much, this was always new for all of us. So they are raising those grounds. Anyway, we will see. Let us first start with you start your submissions flexibly.
Judgment, my lord, it was stated that the constitutional and statutory framework does mandates that the arrested person must be informed on the grounds of arrest, but neither provision prescribes a specific form or insists upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements.
That is substantial. Darshan is about substantial compliance.
Treatable prejudice is so, and they have ever from the beginning of their cases is my lord. Father of the also stated they had first day of their arrest, his arrest.
The 48 notice is not there. It is not there.
24
Yes,
earlier cases were
no,
like
no.
that.
Don't be afraid of that. If it's not there, it's not there. So the question is, though he submitted like that, You don't have to answer why it is not there. That may be a departmental question, but the court will just see whether it is there or not. If it is there, in what form it is there. If it is not there, it's not there. You cannot generate it. So 48 is not there. Darshan talks about substantial complaints. Additional affidavits you have brought in regarding this grounds, new grounds?
No, Lordship, regarding the last rejection order.
Okay. I did not go into this aspect, no? Notice.
No, Lordship.
Okay. You were mentioning something about the this witnesses.
Cases have been examined actually. And after that, actually the accused person didn't engage any counsel. for this. So witnesses cannot be examined properly,
After
So
two
it
witnesses, see.
been reserved.
But now he has a counsel. Now he has a counsel there. Don't have idea.
They have not engaged us, Lordship. But I have seen the TCR today morning, so it was written there that witnesses have turned up, but the examination could not take place because
Because-
they were not, yes, Lordship.
In that case,
Legal aid counsel was appointed.
amicus has to be given.
Yes, legal aid counsel was appointed, but since he was just appearing afresh, so he took time. So it was reflected in the order in that way.
Are you in a position to tell how many witnesses are in the list charge sheet? 11 witnesses. Many. But if 48 is not there, that will probably, give him a right. $24 years. At the time, no, 44 is not there or just a bland format. Not there. Not there.
50 notice.
No, at that time it was 50A it would be. 48 would be 50A.
Yeah, 48 is
50A and
40.
47 is 50.
I'm not pressing on 47.
It is
I'm only
there.
pressing on 48.
48 is not there. At that time it was 50A. Okay. He is in custody since 10/3.
Yes, Lordship.
10/3/24.
As of today, 708 days.
So that's 8 witnesses are only 8. Out of them, 2 have
8
been.
witnesses
Yes, ma'am.
can be complete. 2 witnesses are examined. 6 are left. That's all. No? We'll take the dictation a little forward, a little long.
Should be kindly considered at this stage.
A little bit, I'll dictate here, then other matters to be on there. It's not coming. Baki to follow up. You just take a little bit. Huh? Sit down, please. Oh, to page 70.
Yes.
Hard ones will live understanding count. Yeah, right. And the para 2, 3, 4 you take. This is a subsequent bail application. As earlier bail petitions filed on behalf of the accused were rejected by this court, comma, with the last one on 29/10/2025. Those two. Yashmin, learned counsel for the petitioner, contains three new grounds in the subsequent petition. Dash 1. You can have a seat.
Lordship, it is fine.
That comma. Notice under 48 BNSS, within bracket section 50A CRPC at that time was not furnished to family member of the accused at the time of his arrest. And therefore, in terms of the law laid down by the Supreme Court, the petitioner's arrest was vitiated. It is submitted that though the prosecution has filed an objection, but it has not been stated that any such notice has been given. Second ground is that there is also infirmity with regard to compliance with the provisions of section 36 BNSS regarding arrest, in as much as no proper signatures are available on the arrest memo pertaining to the arrest of the petitioner. Third ground, though charge sheet has been submitted on 10/3/2024, but the trial has not proceeded and witnesses not examined. In support of our contentions, the learned counsel cites the following decisions. Muhammad Muslim alias Hussein versus State. We'll try to locate this is a criminal appeal SLP number 915 of 23. I'll try to locate the citation of this. Second one is Ravi Prakash versus State of Orissa. 2023 Live Law SC 533. This also you have submitted. This Khangengam
Yes,
Manipur case. And it will be Khangeng Mangi Singh, BA 33332 of 2023. Full stop. On the other hand, the learned counsel for the prosecution / NCB fairly submits that on perusing the case scan record, a notice under 48 BNSS has not come. Can I record that? Has not come to notice. I will write like that for your comfortable.
In the witness signature were in the arrest memo.
And that is
should
there,
be-
that I'll record. Fairly submits. It's, I'm not saying your submission as it's not there, but not noticed. Full stop. It is submitted that the arrest memo, however, contains the signature of 2 persons. Full stop. It is submitted by the prosecution that only 8 witnesses are listed in the charge sheet, out of which 2 PWs have been examined so far. And that there were some time elapsed due to due to the petitioner accused not engaging a counsel on his side. The scanned TCR has been received. The accused petitioner herein was arrested on. He was arrested on?
10/3/24.
No, I think it will be earlier because charge sheet was, you might have got that date wrong. Charge sheet was submitted on
Yes, Lordship, there might be a mistake.
because the 10/3, 10/3/24. This is correct, but I think charge sheet is later.
Yes, Lordship.
That's what I do, dot, video, submission. Charge sheet was submitted on dot. Good stuff. Upon perusing the materials and the scan record, I find that the accused was arrested in this case on 10/3/2024 and presently in judicial custody. Good stuff.
Charge sheet was laid down on 5/9/20.
5/9/24.
24, charge sheet.
Date to change, 5/9/24. Good stuff. I find force in the contention of the prosecution that the arrest memo is not bereft of any signatures purportedly of the witnesses, though it is not very clearly indicated that they are the witnesses on the arrest memo. Witnesses on the arrest memo. Good stuff. It is well settled by now that compliance with the notices under 4748 BNSS within bracket earlier section 50/50A CRPC bracket close are essential to satisfy the mandate of Article 22 within bracket 1/21 of the Constitution of India dash as has been held by the Honorable Supreme Court in the cases of Prabir Purkayastha versus Bihan Kumar. It has been held that such compliance is mandatory and in the face of any failure in such compliance, the continued detention of the accused would become untenable and he is required to be granted bail. Full citation to you. Full stop. That 15 notice is reasonable. It is not completely bland, but this is a reasonable notice. But 50/50A they forgot probably. Let me have it. In the scanned TCR, I find a copy of the notice under 50 CRPC. Yeah. That is, we should be. It's true.
Their home, my lord.
Hmm?
When the official team, the inquiry team, when visited their home, accused home, the mother said that that we are aware of this case. Actually, when he was arrested, he called me, means from the office, 5-3
But you
times.
know, that's true. But there should be some demonstrable record actually, because see, these things will also have some vested interest. You know, that sometimes in some cases, I'm not saying this, there may be an effort to, defeat the service of notice, but the investigating authority has to be effective and smart enough to ensure that it is given, right? The notice under notice under 50 CRPC enumerating reasonable details regarding the grounds of arrest. However, I have also not noticed the notice. No, I have also not come across in the record any notice under 50A CRPC given to family member of the petitioner. Yeah, family member of the petitioner. Relying on the case of State of Karnataka versus Darshan, the learned prosecution submits that perhaps the test of substantial compliance and prejudice could be applied in these matters at this stage, considering the serious nature of the alleged offences. On the other hand, the learned counsel for the petitioner contends and submits that in the face of non-compliance with these statutory notices, the clear law laid down in Vihan Kumar and Prakasto regarding the continued detention being untenable should be applied first. I've given my consideration to the matter. Full stop. In the case of Ravi Prakash Supra, it has been held in para 4 as follows. Considering the fact that the notice under 50A CRPC within bracket corresponding to section 48 BNSS at present is not available, or is not shown to have been given, to the family member as mandated as mandated by the law. Therefore, the applicability of the clear principles laid down in Vihan Kumar and Pravir Pukasto cannot be overlooked, and the petitioner cannot be deprived of availing the benefit of these clear provisions laid down by the Honorable Apex Court, holding that in such a situation, the petitioner will be entitled to be granted bail, and that, this should be so even if there are statutory restrictions like section 37 of the NDPS Act. In any case, the petitioner has been in under trial detention for a considerable period since 10/3/2024, and though the charge sheet lists only 8 witnesses, the trial so far has encompassed examination of only 2 witnesses. Therefore, in the given facts and circumstances, and in terms of the law laid down by the Supreme Court in Vihan Kumar and Purkasto, Supra, full stop. I am of the considered opinion that the continued detention of the petitioner would be untenable, and he is required to be granted bail at this stage. In such view of the matter, the petitioner so-and-so, in such view of the matter, allowing this subsequent bail application, the petitioner, accused petitioner so-and-so is hereby allowed to go on a little bit, 75,000. 75,000 with one surety of the like amount to the satisfaction of the concerned learned court, special judge, Golpar. Oh, this is Kamrup.
Kamrup Metro.
Oh, he was. Kamrup, additional session just number 2, Kamrup Metro. And subject to the conditions that he shall not abscond, shall be available for remaining trial. He shall not hamper or temporary evidence. He shall not commit any illegal activities or offenses, including any offenses prohibited by the, any offenses under the NDPS Act. Violation of the bail entail cancellation. Bail petition stands allowed and disposed of on aforesaid terms.
And deeply applies, Lordship, much applies.
Every time the trial is the main thing, always remember this. The bail is important, no doubt, but heavens will not fall. Trial is the main thing.
Item number 6 and 8.
9.
Lordship, item number 8 and 9 of supplementary list and item number 6 of the list is similar matter.
All same.
Same
Same
FIR.
FIR.
Same FIR, Lordship.
Okay.
And today's CD is not received.
CD not received, madam. We have received an message from the police. that
The subsequent bill application. Subsequent bill application. Okay. Acha. They were all rejected on the same day or different dates? We'll check it.
Why not,
9/1.
on day 126
Who is 9,
9/1.
26.
The same day.
8 and 9, Lordship.
Huh?
8 January and
8 January, 9 January.
The subsequent bill application as earlier bill petition was rejected on so and so side passed in so and so date, full stop. The updated case diary was called for, but is not received. And communication has been received that has been sent that the IO is not well. Full stop. Is undergoing and not well and undergoing treatment. Full stop. Issue fresh requisition to the case diary. Then when do you propose to
23, next one.
on 23rd, madam.
23rd February, my lord, next one.
Huh?
23rd February, next Monday.
23rd? I'll have to take it there. Then. 23rd, I will not be there. I'll be on transit. 24th. I'll be in Aizawl for next 2 weeks, but I can take it by VC.
Then what's it before 20?
Say a date of today's week, but the thing is that if he's undergoing again same.
No use. Give it next week. I will take it by VC. No problem. I'll take it by VC
Okay, Lordship.
from Aizawl. No, don't take it on 23rd. I'll be on transit from Delhi.
On
You take it, give it on Wednesday or Thursday.
26th then.
26th. Okay.
Okay, Lordship. And Lordship, item number 3BA308 is my senior is not out of the city today, so matter maybe.
Which matter? Huh?
Item number 3, Lordship, BA308. CD is received maybe to that. Some correcting or vices there.
Please scan copy.
We had called for record scan this year.
Yes, Lordship,
Was a problem.
but my senior is out of city today.
The scan TCR has been received. Learned Counsel, you are Mr.
Or AE you said.
Learned Counsel submits that the leading counsel is out of station and he seeks another date, which is allowed. When would you like to do this?
Friday.
This one you do it this week only.
What tomorrow without?
Lordship, next Friday.
No, Friday I will not be available. I'll go to Delhi from Bhopal, on way to Bhopal.
Then Lordship 19th.
Thursday.
Yes.
What did you open?
Delivery of judgment. Criminal position 701 of 24. 6897.
I'll read out thus in the backdrop of the above discussion, the instant criminal petition would not be maintainable and is dismissed accordingly, giving however the liberty to the petitioner to invoke the statutory remedy of appeal under section 29 of the Domestic Violence Act, and also ventilate the aspect of delay condition. It's dismissed. There was a slight mistake. Limitation Act, no, TV Act. Okay.